directives are legal documents that allow you to spell out the decisions about your end of life care. They allow you to tell your wishes to your loved ones, who you may name as your healthcare surrogate, as well as other medical professionals. One of the advanced directives, the healthcare surrogate, allows you to appoint someone to make medical decisions for you if you're unable to make them yourself. And it also, one of the other documents, the HIPAA release included in the advanced directives, allows you to state who you want to be able to talk to the doctors on your behalf. So you may have people that you want to be able to get medical information about you, say if you're in the hospital, but not necessarily make medical decisions for you. We would list those people in the HIPAA release. So who needs advanced directives? Well, believe it or not, everyone over the age of 18. So if you've got children in college, once they turn 18, their medical information is confidential, and you don't have access to it unless they give you access to it by signing a HIPAA release. So that becomes pretty important. Same thing with your spouse or your other family members. So what documents do you need? The durable power of attorney, the designation of healthcare surrogate, the living will, and the HIPAA release. Let's talk about what those are and why each of them are important. To me, the durable power of attorney is the most important legal document that you can have, because without a durable power of attorney, if you are unable to act for yourself, someone has to go to court and file a guardianship proceeding over you, one in which a judge would adjudicate you to be incapacitated based on doctor's reports, and then all or some of your civil rights will be taken away from you and given to your court-appointed guardian. More civil rights than what a convicted felon has taken away from them. So we want to avoid that. We don't necessarily want to have the court or the government involved in our lives. So we can do that by signing these documents that allow you to have people help you legally while you're alive. So although in Florida, the power of attorney is effective as soon as you sign it, the person, the agent, the person to whom you give the power, has to have a copy of that document in order to act for you. That doesn't mean that you can't act on your own. Of course you can. But by making the power of attorney effective immediately, it eliminates the need, which we used to have in the past, to have doctors sign affidavits saying that you're no longer mentally competent to carry out your financial duties. Well, that whole exercise of trying to get a doctor to sign an affidavit to make your power of attorney spring into effect was a really frustrating one. So back in 2011, the Florida legislature did away with those kinds of powers of attorney, called a springing power of attorney. Now, as soon as you sign the power of attorney, your agent has the power to act for you. Again, doesn't mean that you don't have the power to act. And it's important to note that your agent only has the powers contained in that durable power of attorney. So the reason that becomes important is because, well, this morning, for example, someone sent me a copy of their power of attorney. They needed to get both their mom and their dad on Medicaid. And there were no public benefit language in that power of attorney. So oftentimes, if you get a form power of attorney online, or if you go to an estate planning lawyer versus an elder law attorney to get a durable power of attorney, you will likely be able to do someone's banking or sell their real estate, but you are more than likely not going to be able to engage in any of the legal techniques currently available under the federal law to do Medicaid planning. So I always say all powers of attorney are not equal. Again, your agent only has the power contained in your power of attorney. And if the language isn't there and you're not competent to sign another one, then your loved one might not be able to save your assets to apply for Medicaid. It's important, as you can imagine, to really trust the agent that you're giving the power to. Now, of course, they are serving in a fiduciary capacity for you, meaning that they can get sued if they do something wrong. But unlike a guardianship, there's no court supervision over the execution of your agent's powers under a power of attorney. So if there's a mishandling of your affairs, you or someone on your behalf could bring a lawsuit to sue that agent. But obviously, we don't want to set that scenario up to happen. We want to make sure that the agent that we're picking is someone that we trust implicitly to handle our affairs. So I mentioned before that an elder law powers of attorney is different than an estate planning powers of attorney. Back in 2011, again, when the legislature changed the statute for the power of attorney, they put in the statute what we call these special powers, powers over and above what's contained in a regular power of attorney. And in order to effectuate the usage of those powers, you have to actually initial next to each of the paragraphs in the special powers, whether you're going to give that power or not. So I always include all of the powers, but I give my client, the principal who's signing this document, the choice of initialing either yes or no. That way, if they give the power, it's clearly delineated that they chose yes. But if they chose no, it shows that they were counseled on the power and they decided not to give it. I think that's a better practice than leaving the power out entirely and only putting in the powers that the client said yes to. So it's very clear that the client did or did not want to give that special power. Again, as I mentioned before, can your agent engage in Medicaid planning or veterans benefit planning with the language under your power of attorney? Does it have that public benefit language? Can your agent create a trust on your behalf? That's very important if you want to do pre-crisis planning for Medicaid and you're creating an irrevocable trust of which you're not a beneficiary. So that would be a pre-crisis planning technique, but you might not want to engage in that consultation or design of the trust. So you would give that power to your agent to do. As I mentioned before, was your power of attorney signed before October 1st of 2011? If it was, I do highly recommend that you get an updated power of attorney. Again, it is the most important part of your estate planning that you can have, even though many people think that when we're talking about estate planning, we're only talking about a will or a trust. This set of advanced directives is a very important set of estate planning documents that pertain to when you're alive and to allow you to give help to those people legally that you want to help you when you're alive. The designation of healthcare surrogate. So this is the document that says, if I'm unable to consent to medical treatment, this is who I want to make a medical decision for me. So that becomes really important. You know, in an elder law practice, we deal with many clients who are in their 60s, 70s, 80s, and even 90s. And oftentimes, one part of the couple has a health issue while the other part of the couple is healthy. So it might not be practical to name the ill spouse as the person who should make a medical decision for you. And if you don't have a power of attorney, then the Florida law says that your spouse, if you're married, is the next person in line. So you may want a healthcare surrogate to change that designation to be perhaps a child or a close friend who may have some medical knowledge on your behalf. As I said before, if you don't have a healthcare surrogate, then the Florida statute's going to say who will make a medical decision for you. So if you have a court-appointed guardian, and that guardian's been given the right to make your medical decisions, that person will be the guardian of your person, and they will be court supervised over the medical decisions that they make for you. If there is no court appointed guardian, as I mentioned before, your spouse is the next person in line. If you don't have a spouse, then your adult child or the majority of your adult children who are reasonably available. If you have no children, then it would be your parent. If your parents are gone, it would be an adult sibling, or if more than one sibling, the majority of the siblings that are reasonably available. If you don't have any family, then it would be a close friend or a clinical social worker. So I think something as important as your medical decisions, if you're unable to make them yourself, it's very important that you name the person that you want to be responsible for making those medical decisions for you. The living will is a document that states your end of life choices. So you all may have heard about that Terry Schiavo case, and we're going back, oh my gosh, well over 20 years ago. And that was a case in which Terry was a young woman in her 20s. She was married and both of her parents were alive. She went into the hospital and did not have a written living will. So she went into the hospital for one condition, and she got very ill and wound up being in what's called a persistent vegetative state. So that means she's essentially brain dead. It doesn't mean that there's zero brain activity, but it does mean that if she were to wake up, she would in essence be a vegetable and unable to communicate or do anything to care for herself. So back to the fact that she didn't have a written living will. Her husband said that he had had conversations with his wife and that she did not want everything possible done to keep her alive if she was in a persistent vegetative state or an end stage condition or a terminal condition. Her parents believed otherwise. So there was a 17-year battle through the Florida court system that made it up to the Florida Supreme Court on whether her artificial hydration and artificial nutrition should be withdrawn. Well, after the 17-year battle, up and down the court system, the artificial hydration and nutrition was withdrawn, and she passed in about 10 days' time. So the living will in Florida states that if you're physically and mentally incapacitated, and you're in one of those three medical conditions that I mentioned, a persistent vegetative state, an end stage condition, or a terminal illness, then you can choose to have your doctor and a consulting doctor who makes that decision with your primary doctor that you're in one of those three medical conditions. Then you can choose not to have everything done possibly medically to keep you alive, but rather they would give you what's called palliative care to manage your pain. And my living will goes on to say whether you want artificial nutrition and artificial hydration to be withheld or withdrawn if it's already in, and then you become in one of those three medical conditions, or if you want those things to be continued. And lastly, my living will indicates whether you wish to be an organ donor. You can indicate that on your living will as well. So the living will is your opportunity to tell your loved ones what your end of life choices are. It's guidance for your healthcare surrogate to carry out your wishes as you've expressed them. It takes away a lot of guilt for the healthcare surrogate when they know what you want done. The other document in this advanced directive set is the HIPAA release, and that stands for the Health Insurance Portability and Accountability Act of 1996. I know you know what the HIPAA release is because every time you go to the doctor or even some pharmacies now, you have to sign that you are aware of their HIPAA policies, which is essentially meaning that your medical information is confidential to you. And unless you've signed a HIPAA release authorizing someone else to get your medical information, they can't legally access it. So, when you're, healthy, living out in the community, you're going to what I call community doctors. You're going to your primary care, you're going to your cardiologist, what have you. And so you might sign a HIPAA release at those doctor's office saying, you know, my spouse or my children can talk to the doctor, they can access my medical records, schedule appointments for me, what have you. But you have to remember that if something unexpected happens, and of course, we never think that something unexpected is going to happen to us, but it does. And in that instance, you'll go to the hospital. And in the hospital, it's more than likely you'll have your hospitalist doctors treating you. So you want to make sure that you have a valid HIPAA release that would allow your someone, you know, who's not going to the community doctor, but going to the hospitalist doctors to talk to the doctors in the hospital. So it's important to have a HIPAA release outside of that community doctor's office so that if you've got a child, an adult child out of state, and they want to call the nursing station to get an update on your condition, they can do that. If your spouse wants to be able to talk to the doctors and find out what's going on, they can do that. Even if you're not mentally competent to give that consent, or if you're unable to communicate, the HIPAA release will allow your loved ones to have access to your medical information. Any questions on the advanced directives part? Because I did add a couple slides in on how to avoid probate. So I'm looking for the chat. Please type them here. Yes. So anybody have any questions on the advanced directives, the durable power of attorney, the healthcare surrogate, the HIPAA release, the living will that I just covered? So one question, and it's a question I really get asked a lot, is if you have a durable power of attorney in New York, does it work in Florida? So the law in Florida says if you have a durable power of attorney that was executed validly and legally in another state, and you come to Florida, it is valid in Florida. Excuse me. Fighting allergies this morning, probably with all of you. So it is valid in Florida, but you might need to get an opinion letter from a lawyer in New York saying that it's valid in New York. Now, one of the things that we run into often is that somebody has a New York power of attorney, and I've seen many of those. The person signs it and it's notarized. And that's different from the Florida power of attorney, because in Florida, the person signs it, it's witnessed by two people, and then the principal's signature is notarized. And in order to convey property in Florida, you need to have the two witnesses and the notary. So sometimes, even if you have a New York power of attorney, it is wise if you move to Florida, especially with the public benefit language and the necessity to legally sign a deed on someone else's behalf, to have an updated power of attorney done because of the difference in the execution requirements. So any other questions? Okay, I don't see any other questions in the chat. So I'm going to talk to you about how to avoid probate, because a lot of people think that probate is a really horrible word and they're afraid of it. But I want to just give some insight as to what it is, how it works, and what actually does go through probate. So let's take a few minutes to do that. So probate is the legal process through which a deceased person's estate is properly distributed to their heirs or whoever they listed as beneficiaries in their will, and any debt owed to their creditors, to the decedent's creditors, is paid off. So in general, probate property is distributed according to the decedent's last will and testament, or if there is no will, then according to Florida law. I always say that probate is a lawsuit that you file against yourself after you die. So the last will and testament is a written document that tells the court, the judge, who you want to inherit from you, who your beneficiaries are, and who you want to serve as your personal representative. Up north, they call that the executor, but in Florida, we call that the personal representative. And, you know, say, for example, you have 3 children and you want to disinherit one of the children. You know, a lot of people come in and they think that they have to leave that child $1, but that is not true. You can say, I have 3 children, X, Y, and Z, and for reasons best known to me or reasons best known to them, I'm specifically disinheriting child 3 and possibly their descendants. You don't have to leave them $1. When you die, if you have a will, the will and the death certificate is recorded in the county of your death. And it's a public record. And by that, I mean anybody can read that will. So in my example, child number 3 that I disinherited, if that child wants to complain that I wasn't mentally competent at the time that I drafted my will, or the other 2 children were subjecting me to duress, and they were exploiting me in some way and forcing me to cut child 3 out, then child 3 has a judge who's overseeing the probate file. And child 3 can write a letter to that judge and have an evidentiary hearings held, which will delay the probate and increase the cost of the probate administration, because they want to complain and try to prove that I wasn't mentally competent at the time that I did my will. But it's important to at least have a will, if not a trust, and a trust does avoid probate. So we might talk more about that later. So what goes through probate? And this is really important because a lot of people are so worried about probate, but they don't understand that if you're married, most of the time, with I'd say 90% of the couples that I see, there is no probate on the death of the first spouse. Why is that? Well, first of all, most couples have things jointly titled. So their checking account is husband and wife, their real estate is husband and wife. Should they have an individual asset, such as a retirement account, they typically name their spouse as the primary beneficiary and hopefully name their children as the contingent beneficiary. And same with a life insurance policy or a brokerage account, right? So by what we call operation of law, if somebody's named as a beneficiary, then that asset, regardless of what the will says, is going to go directly to that person. So there doesn't need to be a probate, and often there is no probate on the death of the first spouse. So probate, meaning the will or the Florida law, only applies to those things that were in the decedent's name and the decedent's name alone, without a joint owner and without a beneficiary. And what the probate process does is you file the will with the court, the personal representative is issued letters of administration so that they can gather all the assets in the probate estate. We publish something called a notice to creditors and basically tell anyone that you owe money to at the time of your death that you died. And then they have 90 days to file a valid, timely claim. If they don't, they're forever barred. And then we can distribute the money to your beneficiaries in your will. And that's by court order. And that's how we get things out of the decedent's name and into someone else's name after the decedent died. Again, when they leave things in their name and their name alone. So specific examples, a bank account or investment account in the sole name of the decedent, a life insurance policy, annuity, or individual retirement account payable to the decedent's estate, real estate titled in the sole name of the decedent or the name of the decedent and another person as tenants in common. Tenants in common mean that each of you own 50% ownership. It's different than joint tenants with right of survivorship. If it were the latter, joint tenants with right of survivorship, then basically what would happen is if one person died, we would record the death certificate of that person, and then the real estate would be in that surviving person's name without it going through probate. So the titling of things is important as well. So what can you do to avoid probate? You can make an inventory of every bank account, every asset or piece of real estate in your name. If you're comfortable with your beneficiaries inheriting outright, you would make sure that you have beneficiary designations on those assets. You would review any real property ownership, including the titling of it, meaning if it's in your name or someone else's name, and then how it's held. If it's married, then it should be tenants by the entirety, or tenants in common, or joint tenants with right of survivorship. And you can consider creating a trust to hold your assets to avoid probate. So if you have any questions about that, I'd be happy to help you. Any questions about probate or anything that I went over just a minute ago? And I don't know how to see the chat feature. Here we go. Does anybody have any questions? Yes, I'd be glad to explain what a trust is. So I always think of a trust as a bucket. And it's a bucket that you put assets into, either by titling them, like Kathleen Flammia, trustee of Kathleen Flammia's trust, or by allowing that bucket to be the beneficiary of your assets. So you create this bucket that says who's in charge, meaning the trustee. We plan for, if you're alive but incapacitated, who's in charge as the successor trustee. And after you die, who's the trustee is going to take over after your death, who inherits from you, and how they inherit from you. So you can have a revocable trust, meaning one that can be changed, revoked, modified, or terminated. You can have an irrevocable trust, which we do a lot when we're doing pre-planning to qualify for Medicaid or veterans benefits, meaning we're trying to wait out the 5-year look back period for Medicaid or the 3-year look back for VA aid and attendance. If it's a revocable trust, typically you're in charge, you're the trustee. So I have a trust and my bank account's titled in my trust. And if I am alive but not competent, my successor trustee would follow the terms of my trust to prove that I'm not competent, which says 2 affidavits from 2 doctors. They would sign an acceptance of successor trustee, take that to the bank, and now be able to handle all of my banking because they're the successor trustee. So the reason that the trust avoids probate is because the person who sits over the trust as the trustee is the person who's in charge legally of the trust. So you don't have to have a judge giving somebody the power to act, because the trusteeship designed in the trust gives the person the power to act over the trust assets. So another question I had is, can you have more than one agent be named in your power of attorney? And I'm very big on planning in the alternative. So for example, let's name one person as the agent under your power of attorney, and God forbid something happened to that person, let's name a successor agent. Now, if the question, can you have more than one person acting at the same time? Legally, yes, you can name more than one person with individual authority to act, but it is potentially setting you up with issues. That's because if both people that you name don't agree, so say for instance, you name 2 adult children as agents under your power of attorney, a son and a daughter, and they go down to the Regents Bank and they give the durable power of attorney to Regents Bank, and Regents Bank accepts it. And now both of the kids can act, but something comes up and the son doesn't agree with the daughter on doing a certain transaction at the bank. And now the bank personnel become aware of that. What they're going to basically do is say, okay, we're not going to honor this power of attorney. If the person who gave you the power of attorney isn't mentally competent, then you're going to have to go to court and get a guardianship over that person, because we're not going to be able to know which one to follow if you've given both people individual authority to act. So my preferred way of drafting powers of attorney, and same with healthcare surrogate for the same reason, is to name people in the alternative. Hopefully I answered that question. Any other questions? You're welcome. Well, if there's no other questions, I'm going to go ahead and stop sharing my screen and see if Sonata wants to pop back on.
Hello.
Hello.
Hello. So give me one moment.
Hi, I just got a couple questions. Is it okay if I answer them?
Absolutely. That's what this is for.
I'm happy to. So what's the 5-year look back period for Medicaid? So what that means is when you apply for Medicaid to help pay primarily for a nursing home, you're giving the government the right to look back in time for 5 years, beginning on the date of the application, moving back 5 years. And they're looking for two things. Number one, did you give something away that had you kept it, you could have had more money to private pay for your long-term care? Or did you gift something, real estate, money, during that 5-year look back period, where again, had you not, you would have had more money to pay for your care? So the government does have access to your tax returns. So they're able to see if you had gotten a 1099 from a brokerage house 2 years ago, and we're not telling them what happened with that account or the money in that account. They're going to review that and ask us when we submit our Medicaid application, if we don't tell them at the time that we submit what happened to that money. So that's what that 5-year look back is for Medicaid. Can you explain about an agent not being able to designate another alternate with the power of attorney? So the power of attorney, you as the principal decide who you want your power of attorney to be. And you can name person A, person B, person C. So person A, B, or C can't name someone else to act for you because the power is yours and you're giving it to them. Now, the agent that you named under the power of attorney can sign on your behalf, at least in the language in my power of attorney, another power of attorney at a bank, giving themselves the same power, because sometimes banks have their own forms, and brokerage houses too, and they're real sticklers about the forms that they take. But you can't, if I give the power to child A, B, and C, child A, B, and C can't name a successor. Unlike a trust, you can give a trustee in your trust the ability to name a successor trustee if you want to, but you can't do that in a durable power of attorney. So hopefully that explained that. And I'm checking the chat to see if there's any other questions. Don't be shy, people. It's your Ask a Lawyer free question. How is the house protected from Medicaid? Great question. So in Florida, thanks to our Florida Constitution, if you're alive, even if you're a single person, the equity in your house has to be under $603,000. Am I saying that right? Yes. If you're a married person, you can live in a $1 million home, and your homestead's an exempt asset. And even after you die, if you're on Medicaid and you leave your homestead to a lawful heir, so that would be your spouse, your kids, your parents, your siblings, your nieces and nephews, but not Mrs. Jones, the next door neighbor who helped you stay out of the nursing home. If you die and you leave your homestead to a lawful heir, Medicaid can't make that house be sold after you die to get paid back. Now you've got to be careful, because if you rent that homestead, it becomes a piece of investment property. And if you're on Medicaid and you don't use what's called a ladybird deed to avoid probate of that investment property, then that house will go through probate and Medicaid will file a claim and they will make that house sold to be paid back. So, part of the Medicaid planning is what do we do if somebody is a widow or widower applying for Medicaid and we want to keep the homestead so their children can inherit it? How do we pay the expenses of the homestead when they're in a nursing home and all of their income, because they're on Medicaid, is going to the nursing home? So that's part of the Medicaid plan that we do to make sure that those expenses can be paid if the children can't pay that out of pocket. So hopefully I answered that so you understand it. You're welcome. Any other questions?
Oh, ladybird deed. There
Yeah,
you
I just saw that. So a ladybird deed is also called an enhanced life estate deed. And that's a deed on a piece of real estate that lists a beneficiary. Remember when I talked about having like an insurance policy or a retirement account, and you list a designation, a beneficiary and a designation of beneficiary form? A ladybird deed, and not all states have that, and there are issues sometimes in using it, but a ladybird deed is when you own a piece of property and you want to put a beneficiary on the piece of real estate. So you would retain all rights to the property, but when you die, we would just record the death certificate, and then the property would pass to the person you've listed as the remainderman. Now, there's issues with this in that if your remainderman dies before you, many title companies have taken the position that if you wanted to sell your property and the person you were going to give it to died before you would have to go through probate of their, what I call, unvested interest, because the property isn't in that remainderman's name. But you would have to probate their unvested interest to clear the title so you could sell your own property. So this is why we mostly use ladybird deeds with investment property. We're not big fans of using them on homestead property because of the issues that come up. Any other questions?
All right. Oh, perfect. There you go. All right. Well, I think that was very informative for everyone. I know I learned a lot myself that I wasn't aware of. So I'm actually going to put the contact information email in the chat. So if anyone has any additional questions, please feel free to reach out to admin@Flammia. Oh, hold on a second. If a family is living in a house while someone is in a skilled nursing facility, but they don't pay rent, is it still protected?
Yes, and I call that like a care. I call that like they're being a caregiver. So I would urge the person living in the house, pay the expenses, pay the utility bills, pay the taxes, maintain the home. That's a great way to have a family member live in that home and not pay rent to the Medicaid applicant. We don't want them to, but we do want them to pay to maintain the home. And if we do it that way and we leave the Medicaid applicant's bedroom alone, because they have to have what's called the subjective intent to return home, and if their bedroom's left intact, then of course they could, although medically probably not safe for them to do so, they could move back into their bedroom, and then that still leaves the homestead as a protected asset.